Former constitutional rights lawyer Glenn Greenwald contends that the United States has a two-tiered judicial system, one for the haves and one for the have-nots. This is a little over an hour.
So thank you very much. And on behalf of Professor Chomsky, thank you for that very warm reception. Thanks very much for coming this afternoon, and particular thanks to Professor Chomsky. It is indescribably gratifying to be able to write a book and then attend an event to talk about it with the nation's bravest and most accomplished public intellectual and political activists. So I'm particularly grateful to Professor Chomsky for being here. I just want to begin by making a couple of points that I think will frame the discussion that we're going to have nicely. And I'm not sure what that discussion will be because we haven't talked about it on purpose. But there are a couple of points that I anticipate will help to highlight that I think I'd like to just briefly describe. So the book really makes the argument that the rule of law, as we have always understood it, has been radically degraded in a way that wasn't previously true. And the interesting thing about the rule of law is that it's a term that has a pretty clear meaning by consensus. It's not a particularly complex term. It essentially means nothing more than the fact that in a society we are all bound on equal terms by a common set of rules. And you can look to contemporary legal scholars who define it that way. You can look more interestingly to the 1980s and the 1990s when Western institutions like the IMF and the World Bank began demanding that lending countries that received lending comported with the rule of law, and there were lots of lectures issued about what they were required to do in order to comport with the rule of law. And there was a seminal journal article by Thomas Carruthers in Foreign Affairs that warned that countries that don't live under the rule of law, in those countries, elites can use their superior financial power to co-opt political institutions. And that the critical requirement to live under the rule of law is that political and financial elites cease placing themselves above the rule of law and are subjected to it on equal terms to everyone else. And you go back to the founders, and as much as disagreement as they had, what you continuously find is this emphasis, not ancillary or secondary, but really central, that the American founding, in order to be legitimate and just, had to venerate the rule of law. And this was true despite the fact that founders, almost across the board, believed in the inevitability and even desirability and virtue of vast levels of inequality in all sorts of realms. And yet they continuously emphasized that the only way that that inequality would be legitimate and just is if everyone were equal before the law. Now, anytime you make the argument or point out that the rule of law and equality before the law was important in the founding, you'll be met with the objection, which is obviously an accurate one as far as it goes, so I don't think it goes very far, that the founders violently breached those principles in all sorts of ways, and that the country did as well, and that this concept of equality under law has never been the predominant theme to describe American political reality. And although that is true, the reason I don't think it goes very far is because the important part of that writing and that history is that that principle has always been affirmed as being central, even at the time that we violated it radically. And the reason that's important is because if you affirm a principle and deviate from it in your actions, there's an obvious aspect to your behavior that is hypocritical. But if the affirmation is sincere and ringing and consistent, then those principles, even though you're not comporting with them, become aspirational. They become guides to what progress means, how it's understood, and how it's achieved. So even though the founders violated that principle in all sorts of ways, the fact that they continuously enshrined it and it was affirmed continuously throughout the next 2 centuries meant that most of the events that we consider to be progress in American history were driven by the reverence for this concept that we're all equal under the law, that equality under the law is how we determine if we're perfecting the union. And there's a real value in affirming principles even if they're not perfectly applied. And what I think is radically different about today is not that the rule of law suddenly is not being applied faithfully, because that's always been true. What's different about today radically is that we no longer even bother to affirm that principle. We pay lip service to the phrase, the rule of law, but in terms of the substance of what it requires, you can often, and I would say more often than not, in leading opinion-making elite circles, find an express renouncement or repudiation of that principle. So you begin with the forward pardon of Nixon, continuing through the shielding of Iran-Contra criminals, into the Obama administration's decision to shield all Bush crimes of torture and illegal warrantless eavesdropping, obstruction of justice, the aggressive attack on Iraq, the decision now not to prosecute Wall Street criminals for precipitating the 2008 crisis with systematic financial fraud. All of these acts entail very aggressive and explicit arguments that the most powerful political and financial elites in our society should not be and are not subject to the rule of law because it's too disruptive, it's too divisive, it's more important that we look forward, that we find ways to avoid repeating the problem. And so you really see constant arguments. And you did, for example, during the debate over whether or not the telecom industry should be retroactively immunized for its role in the illegal eavesdropping program, that the rule of law is really not that important of a value any longer. Jerry Ford, when he addressed the nation and tried to convince it to accept the pardon, said, of course I believe in the rule of law, the idea that the law is no respecter of persons, but, and this was the amendment that was concocted for that episode, the law is also a respecter of reality. Meaning that if it's too disruptive or divisive, that it's actually in our common good, not the elite criminals, but in our common good to exempt the most powerful from the consequences of their criminal acts. And that has really become the template used in each of these instances. And that, I think, radically is different than how things were in the past. The other point I want to make, just to begin, and then I'll turn the floor over to Professor Chomsky, is that the other difference is that if we had a society that just decided that we were going to be very lenient and forgiving and merciful when people committed crimes, as I just described we do for elites, you could have debates about whether that was an advisable policy or approach to criminality, about whether or not that would produce good results or not. But if it were applied across the board, at the very least, it wouldn't implicate rule of law issues. There are countries that take very lenient approaches to criminal justice. And if we were a country that applied that same leniency to ordinary Americans as we apply to elites, then there wouldn't be an issue with the rule of law. So for example, if you went and broke into someone's house and bashed the owner in the head with a baseball bat and stole their valuable belongings, and a week later or 2 months later got caught by the police, and you said, look, officer, you got me, I did what you think I did, but isn't it more important that we could look to the future? Why focus on the past? If that were something that worked for you or for people who sold drugs on street corners and the like, then there wouldn't be a rule of law issue. But the fact that that applies only to political and financial elites and not to ordinary Americans is the reason why there's a rule of law problem. At the very same time that we've created this template of elite immunity, over the past 4 decades, we have, in the name of law and order and tough on crime, built the world's largest and most sprawling prison state, one of its harshest and most merciless systems of punishment for ordinary Americans. And the irony that Richard Nixon was the one who received this pardon when, in the 1960s, he rejuvenated his political career by becoming the law and order candidate, taking up the mantle of Barry Goldwater, running against the disruption and arrest of the 1960s, demanding harsh sentences, lesser parole, lesser opportunity for release from prison. The drug war was really accelerated first under him. The fact that he built his political career based on this harsh law and order mentality, and then suddenly when he got caught committing crimes was completely shielded from legal consequence, is really the personification of this two-tier justice system that I'm writing about. And then, of course, the war on terror has brought all new tiers of justice where people accused of terrorism, just accused, can have every right deprived from them, including the right to life, without any sort of legal rights or legal process of any kind. It's really a new class, a class where there's not even a pretense of due process. It's a persona non grata, a sub-person class where the government can do anything without any legal constraints at all. And it's this contrast between the shielding and immunity that we've vested in the elite class, or more accurately, that they've vested in themselves, versus the extraordinarily, unprecedentedly harsh and merciless punishment system imposed on everyone else, that is the real menace to the rule of law, and that I think is the most responsible factor for the loss of faith in our political institutions and the widespread accurate belief that you see motivating the Occupy movement and other widespread citizen rage that our political institutions have lost all remnants of legitimacy and can no longer be used to effectuate change. So I think it's one of the most menacing problems and also one of the most consequential. So.
Well, let me just pick up on Glenn's last comments and say a few things about the rule of law. Happens that last night I was reading the current journal, the current edition of the main journal of the American Society for Historical Relations, the diplomatic history. And there happens to be devoted, several articles are devoted to the Nuremberg Tribunal and to what it means and how it developed and so on. And the lead article points out that one of the most honorable and admired elements of the American historical tradition, the legal tradition, is the principle of presumption of innocence. That is, a person is presumed innocent, a suspect is presumed innocent until brought to a fair trial and convicted with proper procedural guarantees. That's the proudest achievement of the American legal and ethical tradition. And of course, it was recognized at Nuremberg. The British wanted just kill the Nazi war criminals, but Justice Jackson, the U.S. Chief Prosecutor, insisted that even though these people are maybe, the worst criminals in history, they should be brought to trial, subjected to a fair trial, condemned if they were proven guilty. And furthermore, he added that we're giving these defendants a poisoned chalice. And if we ever sip from it, meaning if we ever do the things that they're accused of, we must suffer the same consequences, otherwise these proceedings are a complete farce. The core element of the proceedings, the main crime for which the Nazi criminals were condemned and hanged, was what was called in the tribunal the supreme international crime, namely aggression, pretty clearly defined, which they said is, the tribunal said, is the worst of all war crimes because it encompasses all the evil that follows. Well, I won't run through the way we've applied that to ourselves. But that point is correct. Presumption of innocence is a very deeply rooted principle, not only of American law, but of Anglo-American law, or it used to be. By now, it's simply totally dismissed, and with praise. So, for example, when Osama bin Laden was the prime suspect for 9/11, plausibly, though in fact of the matter is the government has yet to provide the kind of evidence that would hold up in a credible court, and has even more or less conceded it doesn't have it, but undoubtedly he's the prime suspect. A couple of months ago, Obama invaded another country. Commandos apprehended him and murdered him, tossed his body into the ocean without autopsy, and this was praised. This was praised as a great achievement. It's a great achievement of the Obama administration. A couple of months later, the concept was extended in a manner that Glenn talks about in his book, which is a terrific book, I should say. That's the case of Anwar al-Awlaki, an American citizen, a cleric who was accused not of committing, there was some talk about involvement in crimes, but no evidence was presented. The main charge against him was he was a fluent speaker of English, and he was transmitting, he was offering support for jihadi operations. He was killed a couple of weeks ago, and the general reaction was illustrated adequately in a New York Times headline, which said, West celebrates death of radical cleric. Well, it wasn't just death, it was murder, along with another American citizen who happened to be near him. While it's true that there were some who didn't join in the celebration completely, almost all of them criticized it because he was an American citizen, which makes him a person in theory, as distinct from non-citizens who may look like persons but aren't. That's incidentally a core principle of current American law with regard to undocumented aliens. Interesting interpretation of the 14th Amendment. But so he was an actual person, and maybe we're not supposed to murder people suspected of inciting others to carry out terrorist acts. Now, again, there were some critics, and the response who went beyond that and said we should believe in the principle of presumption of innocence. And the reaction to them, actually I was one, was quite interesting. Most of it was the usual shrieking, which you can disregard, but some of it was interesting. And in fact, the most interesting, I thought, was a column by a well-known, respected left liberal commentator, Matthew Iglesias, who wrote that it is, as he put it, amazingly naive to criticize the United States for violation of international law or other crimes, because the international order is established precisely in order to legitimate the use of violence by the West. And by the West, he doesn't mean Norway, he means by the United States. So that's the nature of the international order. It's set up to legitimate our criminal resort to violence, and therefore it's amazingly naive to raise criticisms about this. Incidentally, this is not said in criticism, he's praising it. He goes on to say it's silly even to raise these questions. That happens to be directed to me, and I'm happy to accept guilt for that, on that charge. And if you look beyond and ask just what does it mean to be a non-person, say accused of terrorism? Well, there's a striking example in Glenn's book. As he points out, the first child soldier in American history to be brought to trial for crimes, and that one's worth looking at. That's Omar Khader. He's a 15-year-old boy who was apprehended in Afghanistan, and the charge against him is that when American soldiers were invading Afghanistan and attacking his village, he picked up a gun to defend his village. So that makes him a terrorist, a non-person, and interesting concept of terrorism. He was then first sent to Bagram, secret prison in Afghanistan, then sent off to Guantanamo, 8 years in prison, no charges. After 8 years in prison, he was going to be brought to what's called a trial before a military commission. We'll have to talk about that. But he pleaded guilty and a plea bargain and was given an 8-year sentence in addition to the 8 years he spent without charges. We all know what it means to plead guilty in a plea bargain after 8 years in torture chambers. He actually is a Canadian citizen, and Canada could extradite him, but they are courageously refusing to step on the toes of the master. The concept of terror and presumption of innocence is, by now, so far gone that nobody even bothers to discuss it. It's not, maybe it was once an ancient tradition, but not for us. And Glenn is quite right that the fact that it's been violated in the past doesn't change the fact that by now we've changed the principle. We've abandoned even the principle, not only abandoned it, but forcefully rejected it, even to the extent of saying the international order is established precisely to legitimate our violation of elementary legal and moral principles. Well, it goes beyond one of them. Just give one last example. One of the there was an article recently by a law professor who, in fact, Glenn cites a couple times in the book, Jonathan Turley, who argues that Obama may be breaking the record for a U.S. president for violation of civil rights and law. And you can make a case. One example, which actually involves the former dean of the Harvard Law School, is happens to be Obama's latest Supreme Court appointee, Elena Kagan. She argued a case brought by the Justice Department against a group called the Humanitarian Law Project, Holder v. Humanitarian Law Project, with the support of the far-right justices. Obama won that case. The charge is one that might implicate plenty of people here. The charge is they provided material assistance to a group that's on the terrorist list. The material assistance in this case was legal advice to the PKK, a group that's on the Turkish group, Kurdish groups on the U.S. terrorist list, which means they expanded the concept of material assistance from, say, providing guns or something like that, to providing legal advice and even advice to turn to nonviolent means. That's now criminal under U.S. law, thanks to President Obama, and it extends very broadly. In fact, shortly after this Supreme Court decision, dozens of FBI agents raided homes in Chicago and other cities, destroyed documents, the usual thing when a couple dozen FBI agents raid your home. The charge was they were trying to find evidence that the people they were finally indicted to the grand jury are supporting a Palestinian group and a Colombian group, PFLP and FARC. Well, maybe they are, maybe they aren't. But the idea that expressing support for groups on the terrorist list is a crime, is material assistance, that's novel. And the Justice Department position was explained by Kagan that if you provide legal advice to a terrorist group, say advising them to refrain from terror and pursue nonviolent means, you're legitimizing them and freeing up their resources to carry out terrorist acts. Well, just think how broadly that can apply, as in these cases, which are in fact underway. And a final comment, which has to do with the notion of the terrorist list. That's accepted in the United States as a legitimate category. Why is it a legitimate category? How is the terrorist list established? It's established by Executive Fayette. They don't have to give any justification for it. Those on the terrorist list can't say, I don't belong there. This is just a decision by the executive that I don't like you and we're going to prosecute. We're going to kill you and prosecute anyone now who advises you not to pursue terror. And you look back at the history of the terrorist list, it's very striking. I mean, one person who was just removed from it 2 years ago is Nelson Mandela. The reason is that the African National Congress was characterized by the Reagan administration in 1988, right near the end of apartheid, as one of the more notorious terrorist groups in the world. Therefore, the U.S. was entitled to support apartheid South Africa as it did, not only in its atrocities internally, but in its attacks on neighboring countries, which apparently killed about 1.5 million people. But that's all okay. It's part of the war on terror that, in fact, Reagan had declared. And we have to defend the apartheid regime against one of the more notorious terrorist groups in the world, including Nelson Mandela. By today's standards, Holder versus Humanitarian Law Project, almost anyone who was involved in anti-apartheid activity could be regarded as a terrorist giving material support for terrorism. And as I said, Mandela was just removed from the terrorist list 2 years ago. He can now come to the United States without special dispensation. Now, there are other equally dramatic cases. Now, take 1982. There was a state that had been on the terrorist list, Saddam Hussein's Iraq. But the Reagan administration wanted to provide aid and assistance to Saddam. So therefore they removed Iraq from the terrorist list and proceeded to provide aid and assistance right through his worst crimes, denying the crimes. And in fact, rather strikingly, when Saddam was tried, it was for crimes that he committed in 1982, by his standards, pretty minor crimes, excluding the major crimes, I presume because those were all supported by the United States, and in fact, even denied by the Reagan administration. Well, there was a gap in the terrorist list because Iraq was removed, had to be filled. So it was filled by Cuba. Cuba was added to the terrorist list, partly in order to give some justification for outlandish claims about why we were entitled to support murderous terrorist regimes in Central America, which left a couple 100,000 corpses, much worse thanks to our involvement. And you had to, so the argument was, well, they're being supported by Cuba, so it must be a terrorist state. Fabrication, but that doesn't matter in these cases. However, Cuba was a pretty good choice. In the preceding years, Cuba had been the target of more international terrorism than probably the rest of the world combined, a lot of it coming from right here. So therefore, Cuba went into the terrorist list, and Saddam was taken off, so we could support his major crimes, which were coming. Well, we ought to think about why we even tolerate the concept of a terrorist list. And it's just not questioned. If the government says someone's on a terrorist list, period, end of discussion. And now if you give, say, legal advice or other advice to somebody that they so designate, you're a criminal. And if you're a 15-year-old child who's allegedly picking up a gun to defend a village that's under attack by U.S. soldiers, you sent off for 16 years of prison, torture, and so on. If that's what the rule of law has come to, it's a sad situation.
So I think do we have a few minutes and to start before we get to the question and answer? I want to make sure to leave a substantial time. But unsurprisingly, what we just heard has provoked a lot of thoughts that I want to make because I think so many interesting points were just raised. So one of the interesting aspects of this two-tier justice system and the idea that elites can impose standards on everyone else from which they exempt themselves, it's something that is obviously mirrored in the context of foreign relations, and I think probably was even pioneered there. This idea that the United States imposes standards on everybody else and exempts itself is really the template that then got imported domestically. And one of the fascinating things to do is to go and look at what current political leaders say about things like war crimes investigations and accountability when they're in other countries, doling out sermons and lectures about what those other countries should do. So, for example, President Obama, who promulgated and gifted us all with the slogan that we as good citizens should look forward and not backward in order to justify shielding Bush-era crimes from accountability, gave an interview last year on television in Indonesia, and the Obama administration has been pushing the Indonesian government to prosecute certain war criminals whom the United States has long disliked. And what he told the Indonesians was, it is impossible to move forward into a prosperous future until you've resolved the past. And Secretary of State Clinton has visited both Kenya and Cambodia, where the United States is similarly urging war crimes investigations to proceed, and has told them the same thing, essentially, that you cannot be among the community of decent nations while you continue to harbor and shield war criminals from accountability. And I think the time that she visited Kenya and said that was the time that George Bush's book was released, and he was on every major television station being heralded as a great statesman. And of course, if you read, and I would really recommend that you do, I did this because I heard Professor Chomsky many years ago talk about it and went and read it, the opening and closing statements by Robert Jackson at the Nuremberg tribunals. It's incredibly enlightening, because that was supposed to be the expression of modern justice. And not only did Jackson point out that aggressive war was the kingpin crime, the crime above all others, but he also said that the Nuremberg tribunals would have value only if they were applied not only to the defendants in the dock, but also to all the nations here assembled, meaning the United States and its allies. And yet, if you were to cite that and argue that that meant that George Bush and Dick Cheney and Don Rumsfeld should be prosecuted as war criminals for the aggressive attack on Iraq, there's almost nothing you could do that's more self-marginalizing than that. Even people sympathetic to the idea that they should be investigated criminally for the torture regime or for a warrantless eavesdropping somewhat recoil at the idea that they should be held criminally accountable for the at least 100,000 dead innocent Iraqis, I think because they view the act of Congress authorizing it and the large majorities of the American citizenry cheering for it as something that ought to immunize them from that. And it, I think, shows just how lawless we've become, that you can't even cite the Nuremberg principles and argue for its applicability in the clearest possible case without becoming self-marginalized. Just a quick point about assassinations and the like. I certainly agree with Professor Chomsky that from a moral and ethical perspective, there's zero difference between sending a sky robot over another country and eradicating the lives of non-citizens as opposed to doing that to citizens based upon mere suspicion or even a lack of suspicion, just as a desire to kill them. But I do think there's a practical difference. That is that there is a greater and enhanced danger on several levels when the government begins murdering its own citizens for political dissidents as opposed to citizens of other countries on foreign soil. And the difference is this: I think that, just legalistically, the Supreme Court, for better or for worse, right or wrong, has said that the Constitution applies to foreigners on U.S. soil and to American citizens wherever they are found in the world. But more importantly than that is that when the government starts acting against its own citizens, it really can escalate a climate of fear that can lead to political suppression. And I think that's one of the things that you've really seen in the United States. One of the most striking experiences I've had since I began writing about politics was the first time that I ever wrote about WikiLeaks. This was back in early 2010. And this was before really almost nobody knew who WikiLeaks was at the time. This was before they had released any of their news-making disclosures inside the United States. They had released several important documents and had exposed wrongdoing among corporations and governments in other parts of the world, but not really in the United States, and nobody, including me, really knew much about them. But the Pentagon had prepared a top-secret report, they literally classified it top secret in 2008, that declared WikiLeaks to be an enemy of the state, and it described ways that they could go about destroying WikiLeaks. And it's incredible because the way in which WikiLeaks has been rendered all but inoperable pretty much comports with the things the Pentagon laid out in this 2008 report. But in any event, in this 2008 report, this top secret report, ironically, was leaked to WikiLeaks, which then published it. And the New York Times wrote about it. And the New York Times article basically said there's the Pentagon report that's been leaked that declares WikiLeaks an enemy of the state and talks about ways to destroy it. And I didn't know very much at all about WikiLeaks at the time, but I kind of assumed that any organization that had been targeted that way by the Pentagon was one that merited a lot more attention and probably a lot more encouragement and even support. And so I went and read a lot about them, and I interviewed Julian Assange for the article that I wrote, and I wrote about it, and I posted the audio interview, and at the end I encouraged people to go and donate to WikiLeaks because they had budgetary constraints that were preventing them from going public with a lot of these disclosures. It takes a lot of time and energy to authenticate the documents. One of the things the Pentagon talked about to destroy them was submitting fraudulent documents to them so that when they published it, it would forever destroy their credibility and the credibility of future disclosures. And in response to my recommendation that people go and donate to them, and I provided a link how people could do that electronically and online and through PayPal, dozens of people, literally, told me in many different venues, in the comment section to what I had written, by email, at events like this where I talked to people, that although they agreed wholeheartedly with what I had written about the potential of WikiLeaks to achieve great good, that they were afraid of donating money to WikiLeaks, especially electronically, because they would end up on some government list somewhere, or that they could even be subjected to criminal liability under the extraordinarily broad material support for terrorism statutes that Professor Chomsky just talked about. And these were not people prone to wild conspiracy theories. These were very sober Americans who I had interaction with in the past on other issues. A lot of them were. And I could just tell from the way that they were expressing these fears that they were very rational people. And these fears were well grounded. And the reason it was so amazing to me was because it really highlighted how this extraordinary climate of fear has been created in the United States. WikiLeaks is a group that had never been, and still has never been, charged with a crime, let alone convicted of one. And they couldn't be, because what they're doing is pure First Amendment activity that the New York Times and the Washington Post, in theory, do every day, which is publicize leaks that are given to them by other people. And yet, these were American citizens who were petrified of exercising core First Amendment rights, which is what donating money to an organization whose political cause you support is. And they were basically intimidated from the things we've seen over the last 10 years in terms of lawlessness by what the government has done from exercising these rights. So you can offer all the rights in the world on a piece of paper or a piece of parchment that you want. You don't need to eliminate those rights if you can intimidate and bully the population into refraining from exercising them. And this really occurred to me even more when I wrote for the first time about the extremely harsh and oppressive conditions in which Bradley Manning was being detained. And I remember when I first wrote about it, a lot of people wondered, and I actually even wondered myself, why would the Obama administration basically turn Bradley Manning into almost a martyr and even jeopardize its own ability to prosecute him by subjecting him to this extremely severe, you could call it torture, but at the very least it's inhumane treatment. He was in prolonged solitary confinement for 9 months despite being convicted of nothing. His clothes were taken from him. He was stripped nude and forced to stand naked for many of those days. Just completely punitive measures. And at some point shortly thereafter, I realized that the reason that that was done was the same reason that the Bush administration took people who were completely innocent by the hundreds and shipped them thousands of miles away to a Caribbean island and dressed them in orange jumpsuits and shackles and showed the world what we had done. It's a way of signaling to the world and to would-be challengers to American power, both domestically and internationally, that we are not constrained by law. We don't have any limits on what we can do. If you're somebody who thinks about challenging what we can do, take a look at these pictures of people at Guantanamo who are going to be there for as long as we want to keep them there, even if they're innocent. Or if you're somebody who discovers wrongdoing and serious illegality on the highest levels of our government, and you want to expose it to the world, think about and look at what we've done to Bradley Manning or what we're now doing to WikiLeaks without any even pretense to legal authority and without any constraint whatsoever. It's really the use of law as a means of coercion, which is the exact antithesis of what it was supposed to be. It's those in power using law as a weapon to entrench their power and to shield their ill-gotten gains. And the fact that we can call terrorism whatever we want it to be, the fact that people who, as Professor Chomsky said, take up arms and fight against American troops are terrorists, the fact that we just indicted someone 9 months ago for, quote, raising funds to kill American troops in Iraq. This was an Iraqi who had raised money to defend his own homeland from an invading army. So if you're an Iraqi and the American army invades your country and you take up arms against them, you're a terrorist. Nidal Hassan, who attacked a military base of a country that has spent 10 years proclaiming we are at war and killed soldiers about to be deployed to war, he is a terrorist as well. And yet when the United States or Israel or our allies directly target and kill civilians by enormous numbers, whether recklessly or deliberately, it would be a radical act to describe that as terrorism. This is all designed to be able to criminalize whomever the United States wants, namely those who challenge it in any meaningful way. And that really is the use of law coercively to entrench those in power rather than to equalize the playing field. The final point I want to make, and then I think we can turn it over to questions and answers, is Professor Chomsky referenced this post by Matt Yglesias, who is a byproduct of this school near where we're talking. And he also works for the Center for American Progress, which is basically an organization run by John Podesta, the former Clinton White House official, that was founded, in essence, to justify and defend whatever the Obama White House does. With some exceptions here and there if you search hard enough, but basically that's its function. And the fact that people who write for them do things and say things to mitigate or defend things like assassinating an American citizen with no due process, probably the most radical act that you can think of, really underscores an important point about the way the Obama legacy is being defined and the way that lawlessness has become normalized. So if, 3 years ago, and I say this as somebody who was doing it, if you were to go to an event like this and fill the room with 50% Republicans and 50% Democrats, and you were to talk about and condemn things like wild assertions of executive authority, the idea that the president can act against anyone he wants with no constraints whatsoever, including killing him, that he can do so in total secrecy and with no transparency or checks. And of course, after we killed Anwar al-Awlaki, 2 weeks later, a drone attack killed his 16-year-old son and his 17-year-old cousin in Yemen, and that the US government refuses to even account for what it did there or describe what principles. If you were to talk about those things and the other radical secrecy doctrines the Bush administration used, you would have 50% of the room, the ones self-identified as Republicans, supporting it, cheering for it, justifying it, apologizing for it, and being happy with it. But 50% of the room, the ones self-identified as Democrats, would be feigning anger over it. They'd be objecting to it as shredding the Constitution and right-wing radicalism and all of this. If you were to take that same exact group of people and put them in a room like this now and talk about those same exact things that I just described, you would now have 90% of the room cheering for it and supporting it, or at least justifying it and mitigating it the way Matt Yglesias in that post did, or at least acquiescing to it, and maybe 10% of the room continuing to be angry about it because they were actually angry about its being done the first time around and not pretending to be angry opportunistically for partisan gain. And this has really changed the way that these issues are discussed. The fact that now it's not just the Republican Party standing for this form of lawlessness, but that it's become, under President Obama, bipartisan consensus, which means it's removed from political debate, it is hardly controversial any longer, and it's entrenched as orthodoxy in American political life for at least a generation. There's Jack Balkin, who's a Yale law professor, has talked about how when one party objects to a policy and the other opposes it or supports it, what happens when the other party gets into office and starts continuing it, it becomes no longer a controversial policy, it becomes American consensus and endures without much challenge for at least a generation. That is what has happened to these policies of lawlessness and wild theories of executive power and the right of the American president to target anyone for violence or interrogation or incarceration without any oversight. It has now taken on the face of both parties and is therefore likely normalized for a very long time, and to me that's one of the most significant legacies of the Obama presidency. So with that, I think it's a good time to take questions. I think the mechanics were described at the start. I didn't hear it, so I will rely on you to...
Well, first, thanks to our speakers. We have about 15-20 minutes for questions, so just head down to this mic and try to keep your questions brief so we can get to as many as you as possible. Thanks.
So how do you feel after all these years seeing, and all that you've done, seeing what's happened to our country?
Is that
Yes, to you, Professor Chomsky first.
I've had more years. Well, actually, it's pretty bad, but we should recognize that it's not really all that new. Go back to the modern conception of international law was pretty well founded right after the Second World War. The Nuremberg Tribunal, Charter of the United Nations, and so on. So what was the position of the United States then? Well, the United States was instrumental in setting up the World Court, the International Court of Justice, but at once the United States declared that it is not subject to any charges based on international treaties, meaning the UN Charter, the Charter of the Organization of American States, or others. And in fact, that actually came to the court. It came to the court during the Reagan years when the government of Nicaragua brought charges against the United States for essentially war against Nicaragua, or international terrorism, if you want to lower the charge. The Nicaraguan case was presented by a distinguished Harvard Law School professor. Most of it was thrown out. And it was thrown out because the case appealed to the core principles of modern international law, UN Charter, OAS, and so on. So in fact, when the case was finally judged, it was restricted to very narrow grounds, a bilateral U.S.-Nicaraguan treaty and what's called common international law, what's generally understood. Even on that narrow basis, the U.S. was accused of unlawful use of force, which means terrorism in lay language, and ordered to pay substantial reparations. Well, how did the bipartisan Congress react? By increasing aid to the Contras, increasing the actions just condemned as criminal. Meanwhile, the New York Times, for example, dismissed the court as a hostile forum, a proof that it's a hostile and therefore insignificant hostile forum because it made charges against the U.S. A couple of years earlier, the same Times and other commentators were praising the court because it supported the U.S. in a charge against Iran. Well, that's, in fact, the United States went on to veto, I think, 2 Security Council resolutions which called on all states to observe international law. Well, all of that passed with virtually no comment. Almost nobody knows about this, except maybe some specialists. And it goes beyond. In 1948, the United Nations passed a genocide, condemnation of genocide, major crime. 40 years later, the United States ratified it, but with a reservation, inapplicable to the United States. And that came to the courts too. A couple of years later, Yugoslavia brought charges against NATO for bombing, and among the charges was a reference to genocide. The United States representative appealed to the court and said that the United States would withdraw from the proceedings because the United States was formally entitled to commit genocide, which is true, by this reservation. And the court accepted that correctly. The court rules are that they can't bring anyone to trial unless they agree to the proceedings. So the United States was excluded from the charges. The rest of the NATO powers weren't. That was reported, but with no comment. If we declare that we're entitled to carry out genocide, fine. Then we're entitled to carry out genocide. Now these things are pretty deep. I mean, it's perfectly true that Bush broke, let's take even the torture charges. If you look carefully, it's not so clear that Bush was in serious violation of U.S. law when they carried out torture at Guantanamo or at Abu Ghraib, because the U.S. never really signed the Torture Convention. It was rewritten by the Senate to exclude certain categories of torture. And if you look at those categories, they are the categories that the CIA carries out. The CIA back in the 50s, basing themselves on KGB manuals and so on, redefined torture to allow what's called mental torture, the kind that doesn't leave marks. So, for example, actually even waterboarding. Take Bradley Manning and solitary confinement, which is, of course, torture by any reasonable means, but not by U.S. law. That was then signed into legislation under Clinton. So what's called torture here is a very narrow category, and a good deal of the torture that the U.S. carries out is actually legal under U.S. law. Well, this is discussed by specialists in constitutional law, Sanford Levinson and others, but almost nobody knows about it. Well, these are things that everyone ought to know about.
Okay, yep, go ahead.
Okay, I wanted to ask you about two implications or suggestions that I drew from your book. The first is that excuse me, there's really the unmistakable conclusion that that our officials, judges, politicians, won't or can't, which is more scary, hold powerful criminal behavior accountable, even in the most egregious examples such as torture. And the possibility that the cognitive dissonance that this raises in our officials, that they're not, the constant awareness that they're not fulfilling their role as officials, may be driving this need to sort of scapegoat, to find the most vulnerable, the least politically powerful, for the most trivial offenses accountable. So to be able to demonstrate, okay, look, we're holding a lot of people accountable. They're just not holding, accountable according to law. So it's this kind of charade of judiciousness that sort of passes for lawfulness, and this kind of vigorousness behind it that may be, this knowledge of this imbalance may be driving this kind of and perpetuating the imbalance. And then the second implication was that when our officials give up on law enforcement as their role, that perhaps law breaking, greater extremes of law breaking becomes a means of expressing power. So that yes, our financial system engages in widespread fraud, but only the president can violate the Constitution.
Yeah, those are both interesting and important points. It is true that law and order basically tends to mean get drug dealers off the corner who are selling small quantities of drugs to other adults who want to buy them. And of course that has all kinds of implications. I mean, the drug war is incredibly racist. It has incredibly disproportionate effects on the poor, and yet at the same time, or law and order means, and the rule of law means, pepper spraying protesters and putting them into prison for peacefully assembling, at the same time that the police are protecting the criminals on Wall Street who destroyed the economy and committed fraud on an incomprehensible scale. So I think you're right that essentially these kind of petty transgressions that are punished so harshly is a way of obscuring the fact that the most significant criminals, the most consequential crimes, are shielded, and that the biggest criminals are allowed to continue to run rampant with their criminality. The other point about it as a way of expressing power, one of the fascinating things about this whole idea of look forward, not backwards, and the like, is that at the same time, the very same administration that has invoked this Orwellian slogan as a means of saying that we shouldn't look to political crimes of the Bush era, has waged the harshest and the most unprecedented war on whistleblowers. People who have leaked what unquestionably is evidence of serious wrongdoing. So, for example, the NSA scandal that revealed that the Bush administration was spying on American citizens without the warrants that the criminal law said is required, and that the law calls a felony if you do. The only person to suffer any consequences from that scandal is someone named Thomas Tam, who was a mid-level Department of Justice lawyer who found out the Bush administration was doing this, and one day called Eric Lichtblau at the New York Times to tell him that this was going on. A grand jury was convened. He was continuously subpoenaed. He lost his job. He couldn't afford lawyers. He went bankrupt and had serious emotional and psychological problems as a result of that persecution. All of the people who broke the law have been completely shielded. They went on to write books and get very rich. Only the person who exposed it has been subjected to any form of sanction and punishment. And that absolutely is about expressing power and saying that if you expose any of the things that we're doing that are criminal and wrong, you will be the one who will be punished using the dressings of law to do it, while we simultaneously shield ourselves.
Hi. I hope you both have time to answer this, but first to Professor Chomsky. I came down from Occupy Burlington, Vermont today to be here. And I'm really inspired by the number of people that have risen up to protest the bullying, as you put it, of American elites in many respects through the Occupy movement. Do you think that the Occupy movement has the potential to revolutionize the system to the point that we can topple the power that has so corrupted the rule of law? What do you think the movement will need to achieve in order to achieve and overcome in order to do this?
That's for me? For me, yeah. Well, I mean, I think the Occupy movements, which are now all over the country, in fact, all over the world, are a very exciting development, in fact, inspiring in a lot of ways, and really unprecedented. I don't know of anything quite like them in the past, which makes sense. This is an unprecedented period in many ways. What can they achieve? They've already achieved a lot, I think. They've shifted the range of discussion, which is quite important. They've, at the very least, are laying down a legacy from which you can move on. There are short-term things that they might be able to achieve, which are quite urgent. So to take one, in just a couple of weeks, the Deficit Commission is due to reach its decision, which will probably be stalemate. But whether it reaches a decision or stalemates, it's a real dagger pointed at the heart of the country, either way. Because if it doesn't reach a decision, you go into kind of an automatic trap that's been set up, which is aimed at doing exactly the opposite of what Americans want. It's a rather striking fact. You take a look at polls. First of all, the large majority of the people don't think that the deficit is the problem anyway, and they're right. The problem's joblessness. There shouldn't be a deficit commission. But even if you keep to this minor question of the deficit, very large majorities have a solution. Tax the super rich, bring taxes back to what they once were during our period of rapid growth, in fact. So tax the super rich and preserve benefits. Even Tea Party supporters take that position. Protect the benefits, which are not great, but are crucial for people. Well, the commission, if it reaches a decision, or the automatic process, if it doesn't reach a decision, are going to do just the opposite. They'll cut away at the limited benefits, incidentally ignoring the reason why they're a fiscal problem. Social Security is not a problem at all. That's just thrown in order to try to destroy it. Medicare is a problem because it works through the privatized, unregulated, or virtually unregulated insurance-based healthcare system, which is a complete international scandal. If the U.S. had a healthcare system like other industrial countries, there wouldn't be any deficit. In fact, there'd be a surplus. But that can't even be discussed because the financial institutions are against it. And this goes back to things that Glenn outlines very well in his book. But that's coming right away. And it's possible. It's a long shot. But if the Occupy movements get enough kind of force and energy and influence, they might do something about this short-term problem. Now, that's very far from revolutionizing the society. When you talk about deeper problems, more long-term ones, it has to be understood, and I think is, that you don't get these things overnight. Take, say, the civil rights movement. I mean, that really began in a militant form in the 1930s. It was years of struggle before it even, reached the possibility where you could discuss it. Finally, thanks to very courageous activities, students sitting at lunch counters, freedom riders, all sorts of other things, it was possible to get to the point where Martin Luther King, a great figure in modern life, was able to give a talk, I Have a Dream talk, and some gains were won. They shouldn't be underestimated. The South is a different place from what it was. And in fact, let's take people right around here, Boston. As long as the civil rights movement was aimed at racist Alabama sheriffs, a lot of support for it. As soon as King began to move on to opposition to the Vietnam War and class issues, remember that when he was killed, he was on his way to organize a poor people's movement, and he was killed during supporting a sanitation strike. As soon as he moved on to those, he was dismissed. When you listen to the adulation on Martin Luther King Day, you hear about the racist Alabama sheriffs. Well, gains were won after many years of hard struggle. There's a long way to go. The criminalization that Glenn talked about is basically kind of reinstituting what was done in the not long after the Civil War, criminalizing black life and pretty much restoring the conditions that existed. So there's a long way to go, and that's one of the successful movements. And it's true of other things too. There can be very significant gains, in the long term, really revolutionary gains, but they're not going to come quickly. And the main task of the Occupy movement, in my opinion, is to make use of the quite remarkable network of associations and linkages and mutual support and spontaneous building of communities, make use of all of that to turn it into something that'll be long-lasting and enduring, and will face the inevitable failures and go on to overcome them, which is a hard, long course to follow.
We have just 2 or 3 more minutes and 2 more questions to go, so thanks.
I'd be interested in what both of you think about this taboo subject. The U.S. Attorney scandal, the bogus Acorn scandal, the current redistricting efforts, the making photo ID requirements, the assault on the unions and early voting and registration all seem part of a concentrated war on the right to vote. So first of all, given that these people seem willing to say and do anything in pursuit of their agenda, what is the likelihood that having highly hackable, easily, often failing machines that they own and operate with zero citizen oversight would not be part of their strategy? And do you have any advice for what I can do to get this subject on the radar of my hero, Glenn Greenwald?
Well, I guess you just forced it on my radar because I'm about to address it. But, you know, I think just conceptually, and I will address the specific question in a second, but, you know, it raises the question about whether or not significant economic and wealth inequality can coexist with rough political equality, or whether or not once there's a small faction that can gain so much power through its wealth, then political equality or democratic institutions cannot possibly resist it any longer or remain invulnerable to it. And there are ways, and you know, even the founders talked about this, the problem that if you're going to allow wealth and income inequality, that there is the danger that it can become so concentrated that it'll infect political and legal institutions as well, where it's not supposed to make a difference. And yet we've seen periods of time in American history where there's been lots of wealth and income inequality, and yet at the same time political and democratic institutions have been able to act fairly meaningfully against the most powerful oligarchs. You know, Standard Oil and J.P. Morgan were broken up. Franklin Roosevelt was able to create lots of redistributive and social programs, lots of social progress of the kind that Professor Chomsky was just describing. So you can, it's been empirically proven that you can have significant wealth and income inequality and at the same time political equality that's contingent upon subjecting those who are the most wealthy, the wealthiest, and the most politically powerful to the same rules and limitations to which the rest of us are bound and which we democratically impose on them. And once that starts not to happen, that's when you get the kind of corruption that seeps into all of the other institutions. As far as control over the voting machines and the like, you know, all political processes are subjected to corruption and coercion and the like. I haven't seen evidence that there's systematic fraud on the part of, in terms of our electoral process that comes from voting machine control, and at the same time, I'm not particularly convinced that there's anyone who has such an overwhelming interest, since both parties seem to serve the same interest anyway. I'm not really sure who would be motivated to care enough about that, other than the two parties themselves. But certainly there's instances where there's irregularities, but I think the more important danger is the one that you talked about, which is efforts to start restricting the right to vote more, to sort of return to the poll tax era where people who have certain political views have huge impediments thrown in the way. And that to me is just part and parcel of the generalized trend of using what is supposed to be law and political equality to achieve exactly the opposite. Yep, last question here, and then we can...
Hi, all the hassle in trying to get me to ask this question is reflective of how my civil rights and the civil rights of all the people who can't be here with disabilities are violated by the elite of Cambridge, who also exempt themselves from the basic civil rights of access. For 20 years, I've had the right to full, free, and front door access to every building in the country. But the elite of Cambridge and the good people of Cambridge who support them exempt this elite by using the term historic, which is an ideological term meaning looks good and keeps property values up. And by that process, there is a special entrance for me that I got to go in which the elevator fell 1.5 inches when I got in. When we got to the top of the elevator, we ran into a hand cart and boxes blocking my way out, and then the door into the auditorium was locked. And then when I came in, finally, after knocking to get in, no one knew what to do with me or where to put me. So I call this bullying. It's really a constant ongoing humiliation. Now, of course, the burden that would be placed on the Brattle by making it fully accessible through the front entrance would cost a lot, but maybe that money is meanwhile being used to put the torturing brick sidewalks on my way to try to get to the front entrance, which everyone knows tortures people with disabilities and anyone pushing any wheels, and yet they're all over this area because the elite have exempted themselves right in front of everyone. And unfortunately, you end up participating in it, Glenn, by coming to an event where people can't get to. We're bullied all the time. I was in the street most of the way on the way to get here. And I hope that in the future that you would not speak in a place that didn't have every single person who could come in the front door, because coming in the front door used to be something that was seen as a civil right in itself. Thank you very much. It's emotional to ask for your civil rights.
Yeah, so obviously I wasn't aware of this building ever before. There's laws that require reasonable steps to be taken to provide access to people who are disabled. I've litigated those cases before on behalf of people who are disabled. Whether there's issues around historic designations and the like is something I'm just not aware of. I'm appreciative of your bringing it to my attention, though, and to the attention of everyone here. It's something I'll certainly give some thought to.
If I can just add a word to that, I think the complaints are quite legitimate, but it also bears on the preceding question of can we do anything about it? And the answer is yes, we can. It's very different from what it was 40 years ago. And those changes, which are part of the general civilizing of the country in many ways, that traces back to many things, but in particular to the activism of the 60s and its aftermath. A large part of the civilizing effect of the 60s actually began later, So the feminist movement, for example, has had a huge change. The support for access of disabled people. That's all pretty much post-60s, and it shows what can be achieved by popular engagement, recognition of serious issues, pressure to do something about them, and progress. And progress still has big gaps, but we shouldn't overlook the fact, two facts. One, that there has been progress, and two, that that progress has not been a gift from above, but has been achieved through popular engagement, often struggle. And that's a lesson for the future.
For more information about Glenn Greenwald, visit salon.com/writer/Glenn_Greenwald.